Intellectual property protects ideas. When you look at ideas from the point of view of intellectual property, ideas can be classified into two types of ideas. First type of ideas are abstract ideas, and the second type of ideas are concrete ideas. Intellectual property protects only concrete ideas and not abstract ideas. Now, how do you differentiate between an abstract idea and a concrete idea? The simple differentiation test is whether that idea is implementable or not. If an idea is implementable, then it is a concrete idea. If an idea is not implementable, then it's an abstract idea. Let's say, for example, I come up with an idea of making a machine that can travel back and forth in time. Is that an abstract idea or a concrete idea? It is an abstract idea because I don't know how to implement it. In fact, I borrowed this idea from Wells, and he spoke about it quite extensively in one of his novels. However, if one of you comes up with a stepwise process of making such a machine, and based on the existing state of the art, it is possible to make such a machine, or it is believable that such a machine can be made based on the existing state of science and technology, then that becomes a concrete idea. You need not have made the machine. Intellectual property does not require you to make a machine. It only requires you to have an idea that is capable of being, that machine must be capable of being made. Intellectual property, therefore, protects ideas that are implementable. Now, what do you get if you get intellectual property protection? You get exclusive rights for a limited period of time. Exclusive rights are rights that allow you to exclude others. For example, if you get intellectual property over this time machine, you get the right to exclude others from manufacturing that time machine, using that time machine, selling that time machine, importing that time machine, and offering that time machine for sale. No one can carry out any of these activities without your permission. So therefore, even if you have only one time machine, you will make money out of it because you have intellectual property protection and you can exclude others. If you make multiple time machines, you have significant advantage in the market because nobody else can make it. You will be the only player in the market. If somebody else wants to make it, you can give them permission, and for giving permission, you can ask them to pay you. This is what is normally referred to as licensing. In certain other forms of IP, it may be called as merchandising and by other names. But primarily what you do by permitting others to exercise your exclusive rights is you are licensing your intellectual property. So these exclusive rights open doors for businesses to gain business and competitive value and to open doors for new streams of revenue. However, because intellectual property grants exclusive rights only for a limited period of time, this opportunity is available only for that limited period. Once the period is over, you cannot extend your intellectual property protection. It just comes to an end. And it enters the public domain where anybody in the public can start using your idea. In other words, your competitors and other businesses can start making these products, these machines, and so on and so forth. Therefore, it is important for businesses to know not only how to use intellectual property, but also how to use it during this limited period of time. The period of time varies based on the nature of the idea, and some forms of intellectual property are exceptions to this general rule. They may theoretically be considered to be protectable perpetually. But practically, if you look at it, even those forms don't last perpetually. We'll discuss about those forms as we move ahead.